Welcome to Off the Record, a legal podcast.
Welcome back to Off the Record. Today we are joined by experienced probate paralegal Bizzy Hatcher, serving families across upstate South Carolina. I'm Leanne Lyon, and we're going to give you a step-by-step probate guide today, what clients should expect in probate. Hello, Bizzy.
Hey, how's it going?
Wonderful. Now, you are a paralegal with in probate. Can you tell me what drew you to this field of law?
Well, I started when I was a student getting an associate's degree in applied science and paralegal studies. There was an internship option available, and one of those was a placement at the local probate court. And so I started there as an assistant with the state litigation and getting to know the families of people who had passed away. Just kind of being there with them, alongside them, helping them get through the paperwork of this process when it's an overwhelming time of their life. It's just, I feel, is a very meaningful work, and I really enjoy it.
What should clients expect immediately after someone passes away?
Well, it's okay to take a minute and take a breath. The probate court typically, if there's a will, would like that filed within about 30 days. After someone has passed. But things to get compiled are a death certificate, the original of a will, the obituary, and a funeral receipt. And if they can kind of get those things together and bring them to us, then that really helps us get started.
So what steps are involved with opening an estate, and how do you assist with that process?
Well, that does depend on whether or not there's a will. If there is a will that names the personal representative, then it makes it very much more streamlined. We definitely recommend having a will in place because then that person we will help them complete an application to open probate. We'll file that with the death certificate, obituary, and the will, and we'll get that filed. And if there is not a will, it can be a little bit more complicated in that the state statutes will determine who has priority to be the personal representative. So we may need to get waivers from other family members. We may have to get bond posted for that personal representative. Just all these things that the courts require to make sure that they can oversee the whole process correctly.
Great. Will you explain the inventory and appraisal process and why it's important?
Yes, the inventory is where we list out the assets of the person who has passed away. That would include real estate, stocks, bonds, bank accounts, personal property such as vehicles. And then we also list if there are what we call encumbrances on those property, like the real estate, the property, if there's a mortgage, if there's a lien against the car, things like that. And we get an approximate value. And that helps the court get an idea of what is involved with the estate. And when it comes to dispersing assets, it can help make sure everything gets to where it's supposed to go.
And dispersing assets, as much as everybody wishes it would just go on to the family, it's not. There's also assets that need to go to creditors. How are those creditors notified, and what should clients expect regarding claims and debts?
Well, South Carolina does have an 8-month creditors period. So when the estate is open, creditors have 8 months to where they can file a form with the court that outlines the terms of their claim. So South Carolina statute does state as well that creditors do need to be paid before the assets are dispersed. We can help with those claims, whether they should be allowed and paid in full, allowed and negotiated down, or if there are not enough liquid assets in the estate, then they can be disallowed.
Wow, 8 months. That's quite a long time, actually, to wait. How often can probate take?
Well, That is one thing that we try to prepare the clients for. Probate is going to take probably at least a year, and there are a lot of complications that can arise that are easily handled but do take more time. So I say expect anywhere from a year to 2 years. If there's not a will and there's real property that needs to be sold, we have to file a formal action. We have to get everyone served, everyone notified of a hearing. The court holds that hearing and gives approval to sell that real estate. That might add another 4 months into the process. So if you have family that lives out of town, or maybe they are very diligent with paperwork and it takes a long time to get things back from them, that can add some time. So it really is going to be an individual experience as to how long it can take.
Well, you mentioned real estate, but what about vehicles or other jointly owned property during probate?
Well, many types of jointly owned property, like you have a joint bank account, some stocks, some timeshares. If it's jointly owned, it can pass outside of probate. Some things like cars in South Carolina, it really depends on how your names are listed. If you both have your names, if it's Jane and John, then it's going to be 50-50. If it's Jane or John, then it doesn't have to go through probate. But if it's an and, you have to take your certificates of appointment to the DMV and have that title switched over.
So, what happens when heirs cannot be located or they disagree about how to distribute assets?
Well, that can definitely complicate things and make things take a bit longer. There are ways to try to locate the heirs. We can try using a personal or private investigator. Family members can try to track them down. In some cases, we have to do service by publication, which means we run a legal ad in a newspaper to let them know that the estate has been opened. If there is a disagreement among the heirs, a lot of how assets are dispersed is going to be determined either by the will or by intestate statute. And intestate just means without a will. And so we have to follow the guidelines there that are in place. Usually when it comes down to family members disagreeing, it's going to be over smaller things like jewelry or personal items. And we really try to get the family members to work that out, because if we can't, then we have to file a formal action and a judge will have to hear all that. And it just gets to be timely and expensive. So we really do try to promote them working together as much as possible.
So once you get through all of this, and it's a lot. How do you determine when an estate is ready to be closed?
Well, the court is really good about notifying the attorney or the personal representative saying that the creditor's claim period is over. We have to make sure that all of the assets have been dispersed properly. So the court will want a copy of the new title for the vehicle. They will want to see a deed of distribution for real property, how that's been distributed. They will have each heir sign a waiver, say, and a receipt saying that they got what they're supposed to get. And once all the interested parties have signed their waivers, the personal representative has done an application to settle, and they have done the forms that say, I've dispersed how I was supposed to disperse. Then we file all that with the court, and hopefully the court gives us an order to close. Sometimes they come back and say, well, we want to see proof of this stock that it's been transferred, or, the way that this bank account was dispersed. But for the most part, those are the big things to get through to get it closed.
Excellent. So your role as a paralegal, how do you participate in all of this process?
A lot of paperwork. We're also the point of contact for the clients for the most part. Anything that we have not seen before, we go to an attorney, we speak with them about it, we get direction. We're all the work we do is under the supervision of the attorneys here. But we've been doing this for a long time. We pretty much know the procedure at this point.
Okay, well, that's awesome. And you all know, but people are often new. This is the first time they've been through it. So, what are the most common causes of delays in closing an estate, and how can clients avoid those?
Um, so having the family members get all their waivers and their paperwork in can be trying to get stock transferred can be quite a process because it's not only the court procedures that we have to follow. We have to be doing things in line with the way that the banks want them done and the stock companies want them done. And sometimes they can be particular and their requirements can vary. So it's frustrating for everyone, but occasionally we'll submit all the paperwork to get a stock transfer and they'll kick it back. And we have to get the client to sign things again because, you know, this signature did not have the medallion stamp in the right color. I mean, the things that come up are really crazy. But we do everything we can to try to streamline that process as much as possible.
Well, as we wrap up here today, Bizzy, what final piece of advice would you offer families going through probate for the first time?
Just to try to be patient, expect some paperwork, expect there to be complications, but understand that, like I said, we've been doing this for a long time. We're happy to help guide you through it.
Excellent. Well, that's it for today's episode of Off the Record, today with Bizzy Hatcher. To learn more, visit retbernie.com. And thanks for listening. Remember to like, subscribe, leave a review, and most important, share this episode if you found it helpful.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.